Okay, so I was talking about 4E and 4B funds, all right? Now, the 4E funds are foster care money. The 4B funds are family services money. The 4E funds out of the federal government is $9 billion a year, and it is a dollar for dollar match. So the states have to basically match that money. So it makes it an $18 billion industry. The 4B funds are $600 million, which does not require the same amount of match. And so it's you can see that family services is poorly underfunded. Privatization is the second part of the problem because 90% of the kids in care are lost in the system. Oh, I'm sorry, let me back up. In the 90s, kids in care were being lost in the system. There were several class action lawsuits that were filed by the Children's Rights Organization, and in Tennessee in about 1998, we had the Bryan A. Consent Decree, which was to create special rules for putting children in care. Tennessee Department of Children had to pay about $1 million a year for this oversight by the Bryan A. oversight. Now, let me tell you about that. Okay, let me bust some bubbles here for those in the political arena who believe that that was a good thing. There was no public input. It was run by an ex-juvenile judge who, now remember, he's getting about $1 million a year to run this oversight. In 2018, which is 20 years after this was in existence, I sent a letter to the Bryan A. oversight, the children'srights.org, and I said I wanted to intervene in behalf of parents because all these things were being violated and nobody cared, right? They weren't having any public hearings. They didn't have any type of public input, and they refused. And then shortly thereafter, it was within the next 12 months, they closed the Bryan A. Consent Decree. Okay, so I don't know. I just found that very, very fishy. So now what you know is there's no oversight at the state legislative level because they created an oversight committee and never did it, all right? And there's no oversight at the federal court committee because they put the foxes in charge of the hen house. They had an ex-juvenile court judge who's getting $1 million a year as the oversight person, no public input whatsoever. Now, in addition, when accepting the Title 4E funds, every state is supposed to create a citizens review panel. Citizens being the operative word here, a citizens review panel. And the citizens review panel was to be able to report back and to give reports to the federal agency of the use of the 4E funds. Well, the citizens review panel was basically hijacked by the private contractors and the other quote-unquote stakeholders. So you have people like Camelot and Omni and university social work departments who also get Title 4E funding, by the way, for scholarships. So you have the whole citizens review panel that is hijacked. So now you have no federal oversight, okay? So we have no state legislative oversight, no federal court oversight, and we have no federal oversight from the executive branch by HHS, which is Health and Human Services Department on a federal level. Okay, now what else? So kids are placed in state's custody, and once they're put in state custody, the state court judge has no control over what the state does with those children. No control. The court loses all input as to what happens to a child in custody once they're in state's custody. They have a foster care review board, which is basically a joke. They don't file their reports on time. They don't talk about reunifying the family. And they have no power to do anything. So now let's add that to the no accountability, no consequences, no control, is that the state court level judges who are doing the cases for DCS and who basically have the child within their jurisdiction have no control over what DCS or CPS does with the child. Now, the state legislative committee. So somewhere in your state legislature, there's some kind of committee that handles children and family issues. In Tennessee, we had a child and family committee for a while, up until about 2016, and they abolished that committee because too many people were speaking out, were contacting the people in that committee and talking about the problems. So they abolished that committee, and then under the state committees, they created a subcommittee which is the Children and Family Services Committee. And they really do nothing but review some of the new laws. Well, they are so hammered by the government lobbyists, which there are 40 lobbyists from the governor's office who go and lobby the legislature for support for their executive branch departments, such as the Department of Children's Services, and the private contractors have lobbyists. So in Washington, D.C., I can tell you that in Washington, D.C., there are 144 lobbyists that go and lobby for more foster care, okay? So let's go back and talk about federal funding. So federal funding really had a major swing in 1974 under the Mondale Act, which is also called CAPTA, the Child Abuse Prevention and Treatment Act. It was really a social welfare program. It's thundering again. A social welfare program under the War on Poverty. However, they didn't want to name it anything to do with poverty, and so they said and you can look at the legislative hearing notes on this, they wanted to name it something that had to do with child abuse because they thought everybody would support fighting child abuse. So Title IV funds became very seductive. They are dollar for dollar, so in other words, the state matches every federal dollar, but they have all these strings attached that they have to comply with. It is a use it or lose it strategy, and it is never subject to sequester. However, it requires a child to be in foster care to be able to get that money. So you can see where we're going with this. It also leads to adoption bonus money and what I call the happily ever after stipend for adoptive parents out of the social welfare program. In 1997, under the Clintons, they created the Adoption and Safe Families Act, which created the adoption bonus check money. It started out at $4,000 to $6,000 per child. It's now up to $10,000 to $12,000 per child. It is a bonus check that goes to the state with no strings attached to it for adopting your child out to strangers. Okay, now remember, not only that, foster parents continue to get their fosters who adopt continue to get the adoption stipend money. Okay, so you have children who get removed from their parents because of poverty, and they are placed with strangers, and those strangers basically get a welfare check on that child until they reach 18. And not only that, their child is guaranteed all of their health care. Okay, so they get the foster money continues. They get the state gets a bonus check. They get a clothing stipend. They get health care, and then the DCS gets to close their case. Now I want to talk to you about in East Tennessee. We just had a case that just expounds on how dangerous this is. So it just came out about a case in East Tennessee where these foster parents had adopted 5 children. And of the 5 children that they adopt, 2 were killed. And it was killed by the parents and buried in the backyard. And nobody knew about it until one child happened to be walking out among the streets. And they took that child in and started asking questions and found out that 2 of the children were dead. Okay, dead. Foster parents, adoptive parents killed the children, continued getting the money. Do you understand that? They continued getting the foster care stipend money after they killed the children. Now, who's accountable for that? Well, they interviewed the DCS Commissioner Nichols, who basically said that we don't have any follow-up. We don't have to do anything after that. Now, this is a real problem around the case, right? So you can put these children in the home of strangers who really are nothing special about them. They do a 10-hour or 10-week foster care class. They do a home study basically to see if they have any criminal record, and then they become foster parents. So, and I have said this when I speak publicly, I said this is one of the most frightening things. We don't know what happens to these kids after they are removed and put in foster care, and then especially after the adoption. So again, no oversight, no consequences. Who do you think is going to bring a wrongful death action in behalf of those children who were killed by those adoptive parents? Nobody, because nobody has any rights. Nobody has any right to bring a wrongful death action in behalf of those children now, because typically a wrongful death action is brought by a parent. A parent is really the only one who has the right to do that. So now who's going to bring that? Who's going to bring that up against those parents? Does DCS have any liability? Nope. There's no liability for DCS either. Okay, so in Tennessee Department of Children's Services, I looked at their budget, and you can look this up. You just have to start digging around, and now it's raining. So if it gets too noisy in the background, just let me know. I may have to relocate. But I pulled up the Tennessee DCS budget, and it is $680 million a year. Of that $680 million, $304 million is federal money. They have 100 attorneys on their staff to prosecute parents and take children away, and they have about 8,000 children in care at any given time. So the private contractors, you need to understand that where is that $680 million really going? Well, there are private contractors who are getting millions and millions of dollars. Omni, for instance, gets about $53 million from the state of Tennessee, Camelot about $24 million, and Youth Villages about $65 million. The part of the problem is as well that these people are doing foster care services and then also saying that they're doing reunification services, and they are not. So, and not only that, it is an inherent conflict of interest. Why would you ever rehabilitate a family if you're getting a daily stipend on that child in your private business? Oh, goodness, thank you. So when you think about this business model of being a foster care agency, I want you to think about it a minute from those of you who are entrepreneurs and own small businesses. What a business model this is. So first of all, you have very limited hard dollar cost overhead, right? You don't have to have a big building. You don't have to have a warehouse. You don't have to have logistics. You don't even really have to have a human resources department. I'm going to tell you why. Because their foster parents are contractors, okay? So those of you who have a small business, maybe you have contractors. Let's say, I don't know, let's say you build houses and you get contractors to do some of the work. Well, you know that you have limited liability on those work that those contractors do. Well, that's the model that they use for foster care. So the foster parents are contractors, which means that you cannot sue their parent company, which is the one who would be carrying the insurance. And foster parents aren't required to carry any insurance, which they should be. And they only have to pay out when they're getting money in. So what a delightful business model that is. I mean, we should all have a foster care company. They're also not state actors, and there's no civil rights. There's no civil rights action that you can bring against a foster parent because they're not considered state actors. And the contractors, they're contractors, so there's no corporate liability. Oh my gosh, so now we've talked about no oversight. There's no oversight with the federal courts. There's no oversights by the legislator. There's no oversight by the executive branch. And for the the children that end up in foster care and abused or killed in foster care, there's no oversight and there's no consequences for the children who are suffering through that social work model of child welfare. Foster care fails. Foster care is broken. It fails. We know that. You're more likely to be in prison. You're more likely to not go to college. You're more likely to be homeless, use drugs, and be a failed relationship. And now, generationally, you are more likely to be targeted by the social work model of child protective services. Whew, are y'all getting tired? Okay, so the next topic, so I want to go on and talk about socioeconomic targeting. Often there is a socioeconomic target. Now, race is an issue right now, and of course everybody wants to talk about more per capita of a certain community. Racial communities are targeted. So there are a large number of African American children who are targeted, black children who are targeted, but there are also a huge amount of white children targeted, and often in a middle to lower class of a socioeconomic standard. And those people who have a more difficult time understanding the process, they can't afford a private counsel who charges $200 or $300 an hour. And often within that group of people, their family places are denied. Okay, so the next topic I want to talk about is qualified immunity. Oh my gosh. So I think this is I said this on my outline here. I'm going to try to go for it. Let's see. So let's talk about qualified immunity because it is a hot topic. I may have to make just a whole separate video on this. But since it's raining, maybe y'all don't have anything to do anyway. I don't know if it's raining where you are. Qualified immunity is basically a stripping of our rights. So the first time there was a Civil Rights Act was in 1870, and it had to deal primarily with voting rights because many of the people who were freed as slaves were being harassed and intimidated and not being able to vote. And so the first Civil Rights Act of 1870 primarily dealt with that. In 1964 was the second Civil Rights Act, which is 42 U.S.C. 1983. And basically, it says every person under color of law that subjects a citizen or other person in the U.S. to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the injured party on an action in law or equity or other proper redress. It's now pouring rain. The primary constitutional rights that we are concerned about and we look at, no rain there. Okay, well, the primary constitutional rights, thank you all for giving me some feedback, are the First, Second, Fourth, Fifth, and 14th Amendments to the Constitution. Most of you generally know what they are, but I'm just going to go through them briefly. So the First Amendment is your speech rights for speech, assembly, religion, etc. And the way the government infringes on that is by gag orders, which is called the prior restraint of speech, and then retaliation. The Second Amendment would be your gun rights, the Fourth Amendment against search and seizure, the Fifth Amendment against self-incrimination, and the 14th Amendment, which is a very interesting one and a lot of people don't understand, is the substantive and procedural due process rights that you have. Thank you, Wendy. So under a substantive due process right is a right, a constitutional right that you have. So your substantive due process rights have to do with being free from unlawful use of police force, from excessive punishment while you're incarcerated, and your parental rights and your family integrity rights. The procedural rights have to do with notice and opportunity to be heard, and both have been truncated by our court system. So a civil rights action is basically a tort action. For all you non-lawyers, I didn't even know what a tort was until I went to law school. But a tort is basically a personal injury. So it can be a personal injury if you think about it from a state level. It can be a trespass, a car wreck, privacy, okay, where you can sue an individual for a violation against you personally. That is, all of those things are prosecuted at a state court level under what's called a reasonable man standard. So a jury has the ability to make a decision whether that action was reasonable. So let's say it is a trespass, okay? A trespass, somebody comes on your property and you know, I don't know, brings a bunch of animals or something, and you tell them to get off of your property and they don't, and then the animals destroy your property. Or we've had cases like somebody comes onto your property and cuts trees down, right? One case was like cutting down ornamental trees. And so that is a trespass and there are damages. That is a reasonable man standard. Well, in civil rights, you do not have a reasonable man standard. What the courts have done is they have truncated your rights, your civil rights, by giving government workers a heightened protection, which is called qualified immunity, and means that they must clearly know, it must be clearly established by the courts that that is a protected interest, which is a bunch of baloney, okay? And I'm going to tell you why. All right, so before I get into how we got truncated from the civil rights to qualified immunity, I want to give you a little bit more history on just some of the general human rights violations that have gone through our courts and how the judicial abuse of power has become so unwieldy. So in 1927, the United States Supreme Court issued an opinion on Buck v. Bell. Okay, 1927, okay? And this was a involuntary sterilization. And it was a case, Oliver Wendell Holmes was actually the Supreme Court justice who wrote this opinion. And he said that the law that allowed for involuntary sterilization of those who were lacked mental competency was not a violation. It was, or not a void law. It was a valid law. And he said in there, basically, he said 3 generations of imbeciles are enough. And he said that an involuntary sterilization was no greater sacrifice than a young man being conscripted into the military where he might lose his life. Okay, so that was the comparison he gave. That's 1927 Buck v. Bell. So as we look at, how the judiciary has been involved in our cases and why sometimes we feel so hemmed in. Back in 1871, now keep in mind when this is, 1871 is shortly after the Civil War, and there was a case of Bradley v. Fisher. And in Bradley v. Fisher is when they first created judicial immunity, but they said that judges would have immunity unless it was clearly malicious, unless it was a malicious act. And part of the reasoning in that case was that there was an appellate process. So if you thought a judge had treated you badly, you would have a right to appeal through the American jurisprudence system, right? Through the American judicial system. And then in 1978, which is, keep in mind, nearly 100 years later, there is a case that came out called Stump v. Sparkman, which said even when a judge is malicious, that you cannot sue them. Now, Stump v. Sparkman was interestingly enough, was another involuntary sterilization case. Now remember, in 1927, which was 50 years before this, the Supreme Court had said that involuntary sterilization was okay, but there was a certain presumption that the person who was to be involuntarily sterilized would have some right to the judiciary. However, I'm not even sure in Buck v. Bell if she had that right. But in Stump v. Sparkman, the judge ordered an involuntary sterilization of a young woman because of her mental incompetency, and the young woman ultimately sued, and she lost because they said even where there is a malicious act or there's no right to appeal, the judge has immunity. Now, there were 2 dissents in that opinion. One of them says that, one of the dissents said, a judge is not free, like a loose cannon, to inflict indiscriminate damage whenever he announces that he is acting in a judicial capacity. So if you know what a dissent is, a dissent is like somebody who disagrees with the court, right? They disagree. So that was a disagreement, which and it's a very valid statement. The second one says, the second dissent said that where a judicial officer acts in a manner that precludes all resort to appellate or other judicial remedies that are otherwise available, the underlying assumption in Bradley is inoperative. Okay, so this is so true. Like under ex parte orders, when they take your children, you really have no right of recourse there. So that's how we ended up in the place with Stump v. Sparkman in 1978, saying that we could not sue judges unless there was either clearly an absence of jurisdiction, or it was a non-judicial act. Okay, are you hanging in there? Keep going. Tort liability versus qualified immunity. So in qualified immunity, the court gets to decide whether or not the state actor knew what they did was a constitutional violation when they did it. Oh gosh, it has nothing to do, now here's what's interesting as well. It has nothing to do with training, has nothing to do with supervision, has nothing to do with hiring. Okay, so you would think a government who would have all kinds of resources available to them would constantly be training on protecting the liberties, the civil liberties of persons, but they don't. And they, now with qualified immunity, they're basically see no evil, hear no evil, tell no evil. Because as long as they can escape the federal court saying what they did was a constitutional violation, they don't even have to train on it. Okay, do you understand that? This is so important, so important. I'm going to say that again. Hold on. Until the federal court tells them that specifically this was a constitutional violation, the state level and the local level training is basically see no evil, hear no evil, tell no evil. They do not even have to train people on the constitutional liberties of the civilians. So, and I know, I've seen this personally. So and the way this happened, so I told you that in 1963, we had the Civil Rights Act passed. And shortly after that, 1967, the Supreme Court decided the case of Pearson v. Ray, which justified qualified immunity. Now, I want you to think about this. Oh my gosh. I don't know whether that Supreme Court was a conservative or liberal Supreme Court. Honestly, I can't tell you, and I really would like to look that up. But I want you to remember that in 1964, I get confused if it was 63 or 64 when the Civil Rights Act was passed. Y'all can look that up for me. I think it's 64 because it's U.S. 1983. Okay, 1964. Now, in 1964, what was going on, right? So 1964, there were lots of race riots. It was a very, our executive branch was very Democratic, okay? It was very Democrat. Lyndon B. Johnson is in, okay? So we had a very Democrat executive branch. I don't know where the federal courts were at that time. I mean, we had come out of having Kennedy for 3 years. Before that, we had Eisenhower. So it's likely, it's just likely that that judicial branch was more conservative, but I don't know. So I can't really tell you what the basis of the opinions of the court, but just remember, again, the judges end up making our laws, and they are judicial opinions. And this is why we have got to be so active with our legislative branch, because the legislative branch is supposed to be representing the people and supposed to be representing what we want, okay? What we want. Yeah, and there were war protesters too. Thank you, Trish. So in 1967, the United States Supreme Court justified qualified immunity. Now, let me tell you about that case. That case is called Pearson v. Ray, okay? Now, first I'm going to tell you what the opinion was of the court and how the court summed it up. It said this: a policeman's lot is not so unhappy that he must choose between being charged with dereliction of duty if he does not arrest when he had probable cause and being molested in damages if he does. Thus, qualified immunity began. Now, let me tell you what the underlying facts were of the case. So, Pearson v. Ray was in 1961. 15 black citizens were arrested for gathering in a coffee shop before getting on a bus to head to a civil rights protest. Under Mississippi law, at the time, it was a misdemeanor. Now, listen to this. It was a misdemeanor to congregate with others in public place under circumstances such that a breach of the peace may happen and refuse to move when ordered to do so by the police. This is our country. You need to know what the laws are in our country, okay? This is our country. That law subsequently was repealed, and there were some other things that happened in the courts subsequent to that. But that was the basis of Pearson v. Ray. And so the people who were arrested sued the police officer for violation of their civil liberties, of their First Amendment right to assemble, and the officer was given qualified immunity because he could not have known that it was a constitutional violation for them to do that, okay? It's like, honestly, in that case, it sounds like he was following the law, but it was a bad law, okay? Nobody denies that. All right, after Pearson v. Ray, there were multiple cases which truncated the 4th, 1st, 5th, and 14th Amendments, just case after case after case, and they keep taking our rights away from us and saying, well, the police officer didn't know. The police officer didn't know. And I'm going to give you an example. And then they are like, well, the police officer may know, but the social worker didn't know. So here we go. You want a social work model? Here's how that plays out. So in about 2007, I had a case come to me where the social workers came to the home in the country in the dark with 2 cars of police officers. They all get out of the car. The father is standing outside. They identify themselves. They tell them they want to go inside the house, and he says, wait outside. He goes, wait outside. And he goes in the house, and they all rush behind him and follow him in the house with a police officer first, 3 social workers, and then a police officer in the back, okay? So they held that the social workers did not know that the 4th Amendment would apply to them. Okay, that a social worker, even though a police officer, which was a question of fact as to whether or not the police officer truly had voluntary consent to enter that home, that the social workers would not have known. Okay, so, and they also said that the social workers can rely on the police officers wrongfully entering the home if they believe that the officer was pursuing properly. Okay, that's the kind of mess we're in. That's the maze. Social workers are trained. Well, social workers are not trained very well. I'll just say that, Trish. But all right, so let me move on here. Now, that is I've told you all these things because I want to, and I know the qualified immunity, the social worker model, there is an overlap there because the social work model takes so many more rights away from you and can do things to you, and they'll get legislative support. If you want a social work model, they're going to get legislative support just like they got in child welfare. I mean, it has gotten so bad that the federal courts have said that the government's right to protect a child is equal to family rights, okay? Equal. It means they have truncated your constitutional family integrity right to equally give the government to remove your children. Now, you would think, though, that the government would have to provide competent evidence of substantial risk of harm because that's a constitutional standard, and they do not. All right, so in sum, I just want to tell you that I understand and I agree that in our society, mental health, disabilities, substance abuse, poverty, homelessness are all social issues. They are all social issues that we need to be addressing. The politicians want to keep all of us in a pitiful state of existence. They want us to have that pitiful state of existence because that's the only thing that justifies their existence. Please understand that. They want that. We have resources available. We have education. We have training. We have human resources, all that are available. So we need to engage in activities that support improving the system. We need to engage in activities that support improving the system. That means you need to know who your state legislators are. You need to know who your federal legislators are. I'm going to start writing you a script to call them, okay? And yes, you're right, Tricia. Poverty is job security for our bureaucracy. Our money is used so poorly, and I've just given you an example when I talk about removing children from a home versus restoring a family, okay? I've told you about that. So we need to address these at a community level. And, what kind of programs do we need? What do you need to do? What do you need to do to reach out and to help? And if you have not been through this system, and I know I've posted this through Family Forward Project, and our 14,000 members, most of them have either been involved in the system or they know somebody who has. But I will also share this on YouTube. Y'all need to share the YouTube videos that I have up there, and you need to reach out. Now, let me tell you what I am doing specifically, okay? I have done two things specifically. Under the Family Forward Project, I have outlined a 16-module advocacy program that would be for those who want to advocate for parents who are caught up in the legal system, okay? That is one thing through Family Forward Project. Through Family Forward Foundation, I have, and I will tell you all that I recognize what my spiritual gifts are, and I listen to my spiritual gifts, and I listen to direction that I get, and sometimes wake up and understand that I need to do something. So under Family Forward Foundation, I've outlined a family in crisis ministry, basically, and I've already talked to some key people in my area and have already got a couple people on board who are outside of the system but really have touched these problems through other areas. And I just encourage you, if any of you are interested in those types of activities, either advocacy training or a ministry to really reach out and help families, then those are things that you need to pay attention to, watch out for, and let me know, what you have to contribute. And yes, Leslie, I agree. There are situations where, and I don't know what you mean by wealthy, but upper middle class have been attacked, and that's a whole nother program, I'm afraid. So, yes, and private lawyers. I know I've been hired as a private lawyer and been attacked as well. All right, so I'm going to sign out. I thank you all for your patience today here through this rainstorm. Now it has stopped, and I just had all these thoughts and wanted to share them with you, and want you to share it and just tell the story, learn the story, watch it a couple times so that you can speak intelligently to other people who've not been involved in the system. Okay, signing out, y'all. Love you. Take care. God is good. Bye.